On Ever since 1951. This is The Legend. 105.3, 95.3, WDXE.
That's us, and it's time for Bulletproof Estate Planning with Estate Plan Stan. This morning, Stan Pierchoski, Pierchoski Estate Law in Pulaski, Tennessee, and my good friend now. How are you, buddy?
I'm fine, Jeff. How about you?
Well, we missed you last week. We had an encore presentation of the show last week, and you had travels to do. So
I did. I guess I could have phoned in, but I was down in Miami visiting my latest grandchild.
That's right.
And so that's my second one, and it was. Miss Tammy was in grandma heaven.
Oh yeah, absolutely.
I mean, the child was like stuck to her arm, and every time I said, you need a break when we hold that child, she was like, no, I don't think I need you. I don't need a break. Of course, it was good because every time she handed me the child, perfectly content, within 5 minutes, he'd 0 to 60 screaming about something. But she was in her arms, no problem. And
no problem.
I'm not like rough or anything. Half the time I would sit with a pillow and everything, and it's just. He just didn't want to be there.
He just likes her better.
I guess. I mean, and that's okay. That's okay.
That's a good thing. Yeah, you're happy about that, no doubt.
Well, you know what I did? We were down there from Thursday through Monday, and my son-in-law's a great guy, but not real mechanical.
Yeah.
And they actually had a list of things for me to fix.
Oh, okay.
And I got through all this. I managed to fix everything but one thing. But the one thing was something beyond my ability with the limited tools I had. But,
yes.
But I went from thing to thing, and I hang out with the kids. And we have the 2-year-old now and the 6-week-old grandchildren. So the 2-year-old hung around and watched.
Sounds like a great visit.
It was fun. It was fun. It was in Florida. I mean, it was like
that's right.
70 and 80 degrees. The air conditioner running the whole time. January, and the air conditioner runs day and night.
Oh my gosh, yeah. What part of Miami?
I'm not sure. It's not too far from the airport. I know
not
that.
far from the airport.
Yeah.
Okay.
I don't know. I don't know the different parts.
I'm not that familiar with Miami either. Really, I've been a couple of times.
I think it's on the little more on the northern side. But,
yeah.
But anyway, because I know they're ways from the beach. But anyway, it was a good visit. And so like I said, it would have been difficult to phone in, and I just thought we'd just play a recorded version, and you guys did, and I hope appreciate that.
Yeah.
The ability to do that.
Absolutely.
I actually have a couple that I record and keep for emergencies like that if something would come up.
Sure. Because you're not only here on this station, but you're on the one of the Nashville stations too. You have a regular show up there.
I do, by the same name.
Yeah.
But it's on that 99.7
Super
Talk.
Yeah. When does it actually come on?
It's Sunday night from 8 to 9 o'clock.
Sunday nights.
Yep.
Yeah. Now, do you do it live?
I have done it live many. Yeah, I have. I do it mostly live. Yeah.
Yes, mostly.
And
live.
I've done it a lot of times from up in Nashville, but I have the ability to do it from my office as well. I mean,
okay. That's good.
They showed me how to set up equipment, and I have it, and I can kind of patch in and log into their system, and my producer's up there, and while I'm here talking, and we take phone calls, and it's live.
Oh wow, that's cool.
And I can also submit recorded versions, but I have several that I do pre-record them. For like being Sunday night, you're often there on like Mother's Day and Father's Day and days when probably the listening audience is a little on the lower side. So we sometimes, or I don't want to be in recording that at 8 o'clock on Sunday, or holidays. So I have some that we can play.
Exactly.
And I don't have ones that get played over and over. I keep it refreshed. So
right.
So yeah.
Very good. Speaking of taking phone calls.
Yeah, let's make this question and answer day. Call in if you got a question, because I get them all day long, it seems like, and it's no problem. I mean, most people think they might be burdened by that, but I actually it kind of stimulates me in a way.
Sure.
I don't mind doing it a bit, and what I like about the questions are it tells people, or tells me, what's going on with people, the kind of experiences they're having, what they're running into when they talk to certain organizations or other people, and what they're thinking, stuff like that. So let me give the phone number, and if you want to call in, feel free to do, though. I don't mind a bit. It's 931-766-9393.
Perfect.
Pretty easy one to remember. But, call in and ask me a question about anything.
Yeah.
Preferably about estate planning.
Yes, estate planning.
You want to call in and ask me?
But we'll talk about something else.
You want to call in and ask me what my favorite color is? I guess that's okay. But, I thought I'd start off with some experiences or things that people have brought to my attention.
Yes.
And I talk a lot about avoiding probate. And when you do a trust plan, any trust, we do several trust plans.
Yes.
Let me start with that first. And that is, people say, a lot of folks don't know what a trust is. They say, I've heard about a trust, but I really don't know what it does. Or they'll say, I hear about trust, but I thought that's only for wealthy people.
Exactly.
And neither of those should really be the deal breaker on whether to do a trust or not, especially the size of the estate, because if you have a small, people say, I don't have enough to do a trust. Well, if you don't have much of an estate, it's so much more important now that your assets go where you want them to rather than be consumed by the probate process.
Exactly.
So there's several different kinds of trusts we do. We do your basic revocable living trust. We do the asset protection trust for long-term care. We do special needs trusts for folks that are what we call special needs. We do there's several kinds of special needs trusts, and we do some other type of asset protection trusts that are for different purposes. So we do quite a different one. So it's not just the choice is not just a will or a trust. There are several types of trust. Tennessee has a community property trust. Even though we're not a community property state, we have a community property trust, which I'm glad we're not a community property state because the community property laws kind of suck. I mean, they're really bad. I don't like them, but they do have a couple of isolated advantages. And we've created a Tennessee Community Property Trust to take advantage of one of those advantages. And so we have that kind of trust too. So it's not as simple as a will versus trust. There's multiple kind of trusts we can do. And so if we do a trust, we avoid probate. It doesn't matter what kind of trust you do. All trusts avoid probate because the trust controls the distribution of property after death. Mm-hmm. And so we're governed by our trust code, not the probate code. So we avoid probate that way. Now, the point I was leading up to was every now and then I have some folks will say, well, I came to your seminar and you talk about the disadvantages of probate, and I do talk about several that are big disadvantages. And they say, well, I remember 20 years ago or 10 years ago, somebody passed away and, we inherited some property and, it was not that big a deal. It seemed like it went pretty quickly and pretty smoothly. And that can be possible. Like here's the situations where I see that happen. Typically if you have a sole heir, you got your parents and the last one passed away and there's one child, like a son, he's the only child. Yes. That lends itself to be a little smoother probate-wise because you haven't got the inter-sibling rivalry or somebody complaining they didn't get what they were entitled to. It's all it's robbing Peter to pay Paul when you have a sole heir. If there's expenses to the estate, they're coming out of that person's inheritance, and it's 6 of one, half dozen the other. So that can be a reason. Another one is and I talk about this from time to time. We do have abbreviated versions of probate, and this particular case that came in here within the last 2 weeks brought that to my attention. And so I asked them to bring me some of this documentation. Because from what they told me, I was at a loss to explain exactly what happened. I said, I need to see a little bit more. So they did. They brought in some of the stuff. And lo and behold, it was exactly what I thought it could have been, which is one of these versions of probate. So if you have a probate estate and maybe there's not a lot of property in it, and we can go a small estate probate version. And that's an abbreviated version of probate. There's a couple of criteria. You got to be less than $50,000 in the probate estate, and you cannot pass any real estate. And the second one is what usually puts us out of the small estate, because even folks that don't have a pretty a humble income or whatever, a humble bank account, they usually own a home or something. And so if you have to pass real estate, you can't do small estate.
Sure.
But if it fits, we use it, and it is a quicker, smoother way to go. Now, the problem with the small estate is they just changed that law here in Tennessee last year. Used to be you could do it, and many times people would come in, and I'd say, looks like the solution to you is to do the small estate probate. But you don't need an attorney to do it. And I'll be glad to guide you through it and help you. I'll help you fill out the application and say, but you can go do it yourself, And the people would. Well, just last year they changed that now you got to have an attorney to file the original petition, which raised the cost of it,
Yes.
Yeah, and I don't do probate much, but now there's a couple people that I know that will do that have kept up with it, and they'll do it, and I refer folks to them. But now it's not as simple as doing it yourself. So that's going to be a little more costly than it was. I'm not sure what the rationale was behind the legislature that made that, but they did. Sometimes there isn't any rationale behind it. Sometimes, but anyway, but a couple of things you can do, especially with real estate. And you may have seen this in what you do. Let's say you have somebody passes away and they have a piece of real estate. And they have a will.
Yes.
And they decide to leave it to their 2 kids. Well, if you look at the estate, and all they really have is the real estate and their personal property. Really nothing of any value in the bank or something like that. So, or sometimes we open probate years and years later,
Right.
when the only thing left in the estate is the ownership of the real estate. You know,
Right.
there's a thing called muniment of title, and muniment of title is a way to move a piece of property. It's a probate action, but it's really fast and rapid, and it essentially says, but you have to have a will to do a muniment of title, and it will move a single asset, so this real estate, to whoever it says in the will, and you can do it. It's really just a filing of a document that is not quite a deed, but it's like halfway between this probate action and the deed. It actually transfers the property to those people, whoever the will says it's supposed to go to.
Right.
Now we have something similar if the exact same situation and you pass away and you don't have a will. It's called an affidavit of heirship.
Okay.
And then that is not a probate proceeding, but you have to have a petition that. And you have to veer in an affidavit or two that gets some people that know and understand the family and can swear to the fact that, yeah, these two kids are the only known heirs. And since there's no will, then the laws of intestate succession take over because they distribute to all heirs.
We've run into that.
And so you can do an affidavit of heirship, which does generate a deed.
Yes.
And it goes to those, let's say in this example, those two kids, 50-50,
Right.
You know, joint tenancy, undivided interest sort of thing, and passes to them. And that happens relatively quick too. So those are abbreviated versions of probate, but they are kind of narrow to fit into. You know, if you have any substantial wealth, they won't work.
Sure.
You know, so then you got the full probate thing. So, you know, when this person brought me the documentation, lo and behold, it was a muniment of title, and that's how it moved. And the probate was open something like 12 years after their father's death, and so there was no personal property, nothing else, just the ownership of the real estate was the only thing that really survived.
Wow.
So, you know, you can do it, but it has to fit. Like
Yes.
I said, they have certain criteria. Like if you want to do the muniment of title, you have to have a will. Can't tell you how many times something like that come up, and they said, boy, I hope there's a will there. That would sure make this easy. And we look into it, and sure enough, there's not one. And so now we can't use that because that's a criteria for it.
Yeah. Yeah.
So, you know, there are other things that you can. So when people say, yeah, that went pretty smooth, it really wasn't a problem, you know, you say probate's a real issue and a lot of things to avoid. There are circumstances that can make it less of an impact. So,
Okay.
But again, they're kind of far and few between.
You mentioned at the beginning all these different types of trust
Correct.
that you deal with, and it just kind of made me question the state legislator and the powers that be up there, and then you kind of passed by and mentioned trust code. Mm-hmm. So, does each of those different type of trust have their own set of rules and circumstances? I'm sure they do of some sort.
Yeah, a little bit.
Okay, because I was like, did they have to figure out? Okay, we're going to have this kind of trust, and these are the rules for that, and this kind of trust, and these are the rules for that.
Well, let me explain that. You know, in Tennessee, we have our different codes.
Yeah.
You got the motor vehicle code, you got the criminal code, you got the probate code, you got the trust code.
Yeah.
Bankruptcy, a lot of other ones. Okay?
Right. I don't know if this could be a call for us. It may not. We'll
Remind
see.
me where we left off.
And good morning. You're on WDXE with us. Not. I don't know what that is.
You know, so we have all these different codes. There's some 70 of them. Okay,
Yes.
you know, they different all the gambits of law, you know, the whole
Yes.
gambit of law. And so you have a probate code and your trust code. Well, when you end up in a probate estate, you know, you are bound by the statutory scheme of laws they're called the probate code, and the trust code is about trust. Now, it does deal with, but trust code deals very generally with basically with whatever kind of revocable trust you might have or whatever kind of irrevocable trust you have.
Okay.
The only other thing in the trust code that has any kind of definition to it is a charitable interest trust. Those are a different animal altogether, but nonetheless. And so, yeah, if certain revocable trusts have to be a certain way, and irrevocable trusts have to be a certain way, and there's certain, and they're really looked at as a lot of default positions.
Okay.
In other words, this is one of the things I like about this business, and I got into state law, is because it's the only place in law where when you write a trust, okay, when you sit down, you and I sit down, we start talking about your family dynamics, and we start drafting a trust, we are literally allowed to write our own rule book. Okay. Now, when we write this trust, as long as we keep it in the format of a trust and it's executed with the dignity of a trust, then the courts will uphold whatever we put in there. I mean, we're writing the rule book. Now,
Yes.
the trust code is like a bunch of default values. So if you're silent on something and it needs to be answered, we go to the code and fill in the gap with a default value. Here's an example.
Okay.
Let's say you have a trust, and you say on there, I forget, how many children do you have, Jeff?
I have 3.
Okay, so you have 3 children, and you say, let's keep it simple. And you say, at the second death of my wife and I'm going to leave my children everything we own, a third, a third, and a third.
Yeah.
Just make it simple.
Okay.
Now, and that's all we say. Okay, we say each child gets a third of everything I own. And so then everything I own includes, your real estate, money in the bank, the pots, pans, tables, chairs, everything you own. Now, just suppose at your death, one of the children predeceased. Now, I know it's a horrible thing to suggest and talk about, but I'm just saying, suppose they predeceased. Now, the thing is, if children predecease you know about it because you're still alive. But let's say that happened and you didn't change anything. Okay. So you pass away. There's 2 children that are still living. One that is not, but maybe they have children. And
Yes.
The trust is silent on what to do if you have my 3 children, each get a third.
Yes.
But it's silent on what to do if one of the children has predeceased. Okay.
Yes.
Now now we also have that situation, so that has to be answered, and it wasn't in the instrument itself.
Okay.
So we have to go to the default value. We go to the trust, and the trust says the default value is what we call per stirpes, which means that child's third would flow through the deceased child to his bloodline heirs, and let's say he has 3 children himself.
Yes.
His third would be divided in 3 for those 3 children.
Correct.
So they would each get a ninth of the estate. So
Correct.
now, if you are writing the rule book when you do the trust, now I'm never silent on anything in my trust. If I am, it surprises me.
Yes.
And then I'm not that from that day forward.
Yes.
But, so I always ask the question, what do you want to do? And I tell people, here's your choices. It's whatever you say, for one thing. And so the choices are that one, per stirpes, which is probably the most common one that people want.
Yes.
Or you can do something else. You can do what's called per capita. Per capita would be, okay, if that deceased child passes away, I want their share to go back into the pot and be divided among my then living children. Okay, in which case the other 2 went from a third to a half, right?
Yes.
Now that's that has to fit because you're leaving out the descendants of that child when you would do per capita. But sometimes that's what people want,
Right.
Or if they know that person doesn't have children and is not going to have children,
Right.
Or they only have stepchildren. You don't have to leave you can leave to whoever you want. And so there's reasons for that. Another
Yes.
one is you can just give it to named people. You can do it by representation, and you can also do it to named individuals or charities. You could say something like, my one son was a vet, so if he predeceases me, I want it to go to the Wounded Warrior Foundation or something. You
Yes.
can name places for it to go. So when people ask me the question, like, what happens if, and they,
Yeah.
I don't like to sound flippant when I say the answer to that question is whatever you want it to be.
That's
Whatever we put in the trust is what will be enforced.
Yeah, that's what I'm getting is that you make those decisions when you do the trust ahead of time and you make this plan. You're making the decisions.
That's the
ahead
beauty
time.
of it. That's
Yeah.
the beauty of it. There's nowhere else in law. We got 70-some codes. Nowhere else that I know of, and I'm pretty sure I'm right on this, can you be in a position to write the rule book? And that's exactly what we do with the trust. That is the rule book. And our courts have said they will enforce what's in there. They said the trustor, that's the maker of the trust. The trustor's intent is paramount.
Yes.
And at death, will not disturb that intent unless there's compelling evidence to do so.
Sure.
And that's a high standard.
That is a high standard.
And I don't see that anywhere else in the law. That you sit there and write. And I've gone over case law occasionally here and on my Sunday night show whenever something comes out that is on this subject. And I've seen case law where the courts say that.
Right.
I think not too long ago we talked about the brother and sister, where the mom left property to the brother and sister, but said if the brother is still married to who he's married to now, then I don't want him to get his inheritance outright. I want it to go to his sister, and she controls it. But if he's not married to her, then he can have it outright. I talked about that maybe a month or two ago, I think.
That's a tough family situation.
I'm saying
there,
you can read between the lines and
Yes.
see how mom felt about the spouse of
not
the son.
very not a very good circumstance.
But the court said this trust is clear. There's no ambiguous language, and the son was married at the time of death. And they said our decision is clear. We will follow what the trust says because it's not ambiguous. There's no illegal purpose in there. I mean, if you put something in there that's illegal, they're not going to uphold that.
Right.
But there's certainly, and that's what they did. And I mean, the son appealed that thing all the way up to our Tennessee Supreme Court, and they said, this is exactly what mom wanted. And you are a beneficiary of a trust by the whim of the trustor. They put you in, they take you out, they can modify how you give it to them.
Yeah.
So you can say in there, all right, son, not only can you not be married to that person, you got to have a 5-year history of no drugs or alcohol.
Yeah.
You got to have joined the church and become an upstanding Christian. I mean, you can give this endless list.
Oh, my
and
gosh.
some of the things you may even say, well, that's just absolutely unreasonable to me.
Yeah.
That's what will be enforced because you are writing the rule book. Now,
Wow.
I'm using that as a kind of
an extreme example.
overboard example.
Yes.
But you could do it if you wanted to. That's what makes it such a powerful tool. You don't have to say, many people say a third, but it doesn't have to be that way. And you can always modify it. So if you got one of those children, yours are still young, still under the age of majority, right? So, I mean, and I'm not picking on them, I'm just using them for an example, but one of them could get into a bad habit.
Sure.
You don't know how they're going to turn out, right? I mean, it could happen. And if that happens, now your circumstances have changed and you want to go back and visit, say, I'll use one of my children as an example and hope he's not listening. But anyway, I had a child that was a spendthrift.
Yes.
A spendthrift is a person who, I guess the better word is not financially responsible.
You're just not disciplined yet.
But not financially responsible isn't a bad thing. I mean, he was 18, 20 years old. You know what I mean? I mean, he's just not. And so, I know if something happened and he got a pretty decent inheritance, I mean, he'd blow it on his jacked up truck and go buy himself a Gator or a Polaris. I mean, not that there's anything wrong with that, but when you get inheritance, I just think it's a shame to just squander it, you know? And I say that because I have a lot of people that come in and do trust plans and say, I got an inheritance and I blew it and I'm just not letting my kids do that because I could have used it later in life and I don't have it.
Yeah.
And so you want to control that. Now, here's a perfect example. I put some tight restrictions on his inheritance so he couldn't blow it all at once. Or at all, really. I put somebody else in control of it, his sister.
Yeah.
Now, she's got a head on her shoulders, and she knows what's going on. She just is. I mean, I'm not playing favorites. She just is financially responsible.
Yes.
And she would control it. And she's always been tough on her two brothers, and so she would stick. He could go crying to her, and she'd say sorry. So she was the perfect person. Now, some years later, somewhere around age 26 or something like that, my son had a light bulb went off in his head, and he became a different person.
Yeah.
I mean, he got a good job. He bubbled up to management. He got good pay. It's just like the light finally went off, and he got it.
Yeah, yeah.
and now he's pretty frugal with his stuff. I mean,
Sure.
He told me one time he got to get this. He gets a call from the bank, and they said, "Would you like to put some of this money you have in your account in one of these what are they called, Casaba account that earns a certain amount of interest because you got to have certain amount of money in there, right?
Exactly.
I sort of got wind of the kind of money he's been saving, and I thought, good grief, is this what happened to my child that was here
blowing
5 years
everything?
ago?
Yeah.
So I went in and I removed all those restrictions because now the problem that I was trying to solve doesn't exist anymore.
Yeah.
So I took them out, and he can now pretty much have access to his inheritance and do whatever he wants with it because now I trust his financial responsibility.
Yeah.
Now, circumstances change for the better, right? Circumstances can change for the worst. You have a child, everything's fine, and next thing you know, they're addicted to drugs. And I use that as an example because we see a lot of it. And people can imagine that and say, yeah, that would be a real problem. And I don't want to leave, I'm leaving my child a third of everything I own because I got 3 kids too. And I'm leaving him a third of everything I own, but if he's got this bad drug habit, I know what he's going to do with the money. I mean, that's what people that have that kind of conduct do. And you want to take it a step further. If I leave him a bunch of money and he's got a drug habit, there's a good likelihood I will be the instrument of his destruction.
Yes.
Now, let's just get down to where the rubber meets the road.
Yeah.
You got a cocaine addict, and they run into money. Their inheritance is going to go up their nose, and it probably will kill them. If it doesn't kill them, it will certainly make the addiction worse.
Yes.
I mean, that's just the bare truth of it. I got exposed to a lot of that kind of stuff when I did criminal defense work, and those folks need help to rehabilitate. Now, so what we do is we protect the inheritance and maybe use it for rehabilitation. Of course, people got to be willing to do that. But nonetheless, wouldn't that money be better used for that? I mean, if you were still alive and you had a say in it, and they said, Dad, I'm going to go to rehab and get rid of this terrible problem, but I can't afford it. I mean, you'd write a check in a heartbeat, right? So same thing happens after death, if somebody's in control of that. And you could save their life doing that. I mean, that is a good example to use because people can envision that.
Yes.
But, if you think of your own family dynamics, there's many, many reasons why you might not want to just give it to them outright. Because, a lot of people are worried about in-laws, their spouses. They think, okay, I want this to go to my child, but I kind of don't want their spouse to get it. Some people don't worry about it, but some people do. That's a common thing. And one step further on the spouse thing, what people also are worried about is, what if my child gets divorced from that spouse?
Yes.
That's a problem. So, with a trust, we can do what I call divorce proof. You can leave your whole 1/3 to your child and protect it 100% from a divorce should a divorce happen.
Wow.
I was just down visiting my daughter. She's my 3 children. She's the only one that's married. My son's getting married in March, and the other one I'm still hopeful.
There you go.
But my daughter's been married 7-8 years, and my son-in-law's a great guy. I love him to death. But what about 20 years from now? Right? I mean, everybody's in love when they get married. You don't know. Nobody sees a divorce coming. I mean, you do kind of in the end stages, but you don't get married and think a divorce is going to happen. So, but when it does, I don't want her adversarial divorcing spouse, that's what he is at this point, walking away with half the inheritance I leave for my daughter. I don't want that. Now, even if I'm the dad,
yes.
She's my daughter, she's my baby girl, and even if she's at fault for this divorce,
Yeah.
I don't care. She's my daughter.
She's still your daughter.
This is me. This is me, Stan, speaking about my feelings.
Yeah.
I want her to get her inheritance.
Yeah.
That's all there's. Now, I guess there could be some really egregious circumstances I might change that, but basically, I don't care why they're getting divorced. I'm on her side.
What strikes me about this, Stan, is you and I have talked, and I learned more and more about trust and the benefit of doing this, is having someone like you who can go through the unforeseen scenarios, because even just in this conversation this morning, there's things that I may not think about. Mm-hmm. And so you need somebody that's had the experience and they've looked at all those life circumstances that can come up. And when you plan these things, have those questions asked, and because you probably never thought about them. You may not have ever thought about, well, what if this happened, or what if that happened? And you just, and so what doing something like this does is forces you to think for the future of your estate and your children's future, mm-hmm. and what you want to happen. And so you can make those plans, answer those questions now, and not leave it for everybody guessing later. And I've seen that happen so many times with the states and working with the states on the real estate side of things. Mm-hmm. And sometimes it takes a long time for people to sort it out.
Yep, it sure does. And I often say I'm in the what if business.
Yes.
And I can what if stuff to death.
You can what if, in fact, it's kind of, and you might even get weary of it, but at the same time, it's worth the task. Mm-hmm. It's worth the work. Oh, yeah. It's worth the work to go through the process, answer those questions, the what ifs. What if this happens, then what? We do will plans for people that want to go that route. Yes.
I often say if you get informed and you make an informed decision about whether you want a will or a trust, and you decide to go with a will.
Right.
That's okay as long as it's I prefer it be an informed decision.
Right.
Don't say, well, I think a will is my only option, so that's what I'm going to do. Once you hear what the other stuff out there is, and you still want a will, and some people go that route. Now, I can think of a case not too long ago where I had a couple. It was a second marriage for both,
yes.
And they wanted to do a will plan. So we were doing it, and I was doing the intake, asking the questions. And they both had children of their own, right? And typical husband and wife wills, say things like, well, I leave everything to my spouse, but if my spouse predeceases me, then I want it to go to the children. I mean, that's pretty typical.
Typical.
I call that a reciprocal
kind
will.
of a normal thing.
Yeah,
yes.
I mean, I see that. That's 95% of it. Now, this is the way the couple wanted to go. And I said, okay, let me just walk forward a little bit. Let's fast forward this. What about the children that you each have? They said, well, I want the other spouse, I said, what do you want? If the other spouse is the surviving spouse, I want them to leave to the children. And it's like, well, we have to say that, and we haven't said it, because if you pass away and you say, I want it to go to my spouse, everything you own goes to your second spouse. Now they own it.
Yes.
And when that's just, I don't know how to expound on that other than to say they own it. That's the beginning and that's the end.
Yes.
Well, can they do this? Can they do this with it? They own it. Can they give some to my kid? They own it.
Yes.
They do whatever they want with it.
Yes.
And if they want to leave it to their children, they can do it. There's nothing that's going to enforce them leaving it to your children if you're the first one to pass away. We have to deal with that. So you have to say, if I'm the first death of this marriage, I want to distribute the property that I always meant to go to my kids then at that death. That's typically what we do. I mean, it can be whatever you want again. Now, if you want it all to go to your, if all said and done with, you say, yeah, I want it all to go to my spouse because I trust that she'll leave it to my children. And I'll say things like, as an attorney, I just have to advise you that there's a risk there that might not happen.
Yeah.
It's a fine line. I don't want to be insulting, but as an attorney, I've got to let you know that if you do that, there's a risk. Okay. But so I tell people, if you absolutely positively want that to go to your kids at somewhere down the line, we have to say it, and then it will. That sort of thing. So there's that. And I also had one not too long ago where somebody was doing a will, and as I probed into the what ifs, found out that he was married many years ago, but he's not been his wife 20 years ago. He said she was, he said something about, I don't think he ever actually used the word divorce, which is what perked my interest. And I asked,
Yes.
so let me ask you this. You were married with a statutory marriage. Okay. That's with a marriage license, right? And he said, yes. And they were married down in Alabama or whatever. And I said, so were you divorced with it's a statutory divorce? There's only two ways out of a statutory marriage. If you go to the church and say, I do, and the preacher says the words, by the power vested in me in the state of Tennessee.
Yes.
Okay. Those are the magic words that creates, it's a statutory marriage.
Yes.
If you have a statutory marriage, there's two ways out of that marriage, and two ways only. One is a divorce, a statutory divorce, and the other one is death.
Yes.
Okay. So, so you choose which way you want to get out of the marriage.
Yeah.
But so I'm asking. So did you have an actual divorce? Where went through an MDA, marital dissolution agreement?
Yeah.
He said no. We just went our separate ways. So I said, all right. Now here's what you got. You're leaving everything to your son. He had a sole son that he loved. He just loved to death. It was his pride and joy. He left everything to him. And I said, you have someone that enjoys the legal term spouse. When you say spouse, everybody uses it all the time. My spouse, my spouse.
Yes.
That is a legal term, and it's created from this statutory marriage, and it is extinguished and terminated at a statutory divorce. If you divorce, you are no longer enjoy the legal status of spouse to that person. Now, if he leaves everything to his child, this person can surface, and I'm guarantee you they will. Especially if there's any money in the estate. They will surf and say, I'm a spouse. And you cannot disinherit a spouse in the state of Tennessee. We have something called elective share. And write a will and put the words in there, strong words that gold digging SOB, I don't want her to get a penny, I hate her, nothing for her, zero, zip, nada, nothing.
Yeah.
How strongly do you say that? You cannot disinherit a spouse in the state of Tennessee. If they have that status, they can come back and exercise elective share. An elective share will let them get as much as 40% of the estate. Now, your sole wish was to leave everything to your son.
Yes.
And if I hadn't brought that to their attention, I'm saying this is not what's going to happen. Because I'm going to assume this person's going to surface because 95% of the time they do, but I'm not going to make the assumption they won't. So
yes.
They're going to come up and they're going to take close to half of your
stuff. So what's the
stuff.
solution for this?
Well, that's the solution was a divorce. Get a divorce. I mean, there's no other way.
Go through the process and get the divorce.
And if I remember right, it turned out that the other person was unaware that had already got remarried.
Oh, wow.
Which made they had to deal with the legality of the second marriage, which means you're not able to get married. But they were in another state, and I talked to an attorney where they were, and they had something they could do. It wasn't really an annulment, but it was something they could do to correct that. Yeah, they walked their separate ways. 10 years later, she got married, and it's an illegal marriage technically because you can't be married to someone else when you marry a person. And even though it's a legal technical marriage, and I get in reality they're not together, they don't have anything to do with each other,
right.
They don't have any assets together. I get the concept, but from a legal standpoint, there's this thread of attachment that we got to deal with. So I think we got that all cleaned up and we got the way it was. But if I don't what if that.
There's the complete and utter emotional separation. Everybody's happy and done with each other. But the legal aspect hadn't been satisfied.
That's right. You can, and sometimes I get the reverse. I get somebody they were married to somebody, they got divorced 20 years ago, and they just decided to stay together, but they're not married anymore. And so,
there's an interesting scenario. Actually,
that happens. I don't want to say often, but it happens probably more than you think it would.
Yeah.
But now that's not as difficult Okay, it's not difficult because they're not spouse, but you can still leave to them. We just have to name
That's
them.
true.
We just have to name them. We
Name
just have
that
to say
person
it, yeah.
as the heir.
You know, I don't often like to say spouse because spouse can change.
Interesting.
You know, if they say I leave this to my spouse, it can change. You know, if you get divorced and
Yeah.
remarried, now we have to revisit what we said for spouse. Maybe we ought to name the person. Or even say my now the spouse I have at the signing of this document. Or there's different ways to deal with it. So, but yeah, if you're just not married, there's certain things we can do.
Interesting.
Because they always raise that issue about we're not married, and I know Tennessee doesn't recognize us being a couple and stuff like that. And I always have to explain to them that's not exactly what that means. People hear all the time say, "Oh, Tennessee doesn't recognize common law marriage."
Yes.
And so I think I don't know what they think when they hear that. What do you think if I tell you Tennessee does not, and that's a true statement. So let me say it this way: if I tell you Tennessee does not recognize a common law marriage, and you say somebody that's living together for 20 years like that, what does that mean? What does that mean to you?
Well, I'd have to educate myself on it a little bit because technically they're not married.
That's true, but I mean, when they say Tennessee doesn't recognize it, I mean, it almost sounds like if Tennessee finds out about it, they're going to make them move out of the house. You guys can't live together like this. You got to go this way. That's kind of what it sounds like.
But they have no
right?
legal status.
Well, that's kind of right. You're kind of right.
Yeah.
So, since
It doesn't mean they're going to make them separate. It just means they don't have a legal marital status.
Yeah, and let me tell you exactly what it means because now that we're on it, what it means is this: they don't recognize it because it's not a statutory marriage.
Okay.
Now, let's just say, and here's where this comes up: the not recognizing it, and this is where it actually came out of one of our court cases. It became part of our common law. Is they said we don't recognize common law marriages. What they mean is, say they want to walk their separate ways and they want to go through some kind of divorce. Well, they won't give you a divorce because you're not a spouse. You got to be married to have a divorce. You have to have a statutory marriage to have a statutory divorce because a divorce is a creature of statute. Now, let's say you have children in those 20 years you're living together. Now, and the husband says, "Get out. I don't want anything to do with you anymore." And you think, you know what? I need some kind of alimony or I need child support. So they file a petition in court. And the court's going to say, listen, we can't give you child support. Child support is a statutory remedy during the divorce proceedings. We don't recognize a common law marriage, so you don't get any of the legal remedies of a marriage or a divorce because we don't consider it a marriage. You see what I mean? So you can't get child support. I mean, well, you can get child support when you're not married, but you can't get things like alimony or spousal support. And the child support you get, you have to go through pretty much the juvenile court. Because there's a lot of people that have children when they're not married that have to pay child support. It doesn't escape it. But the other statutory remedies. Now that's if you can remember. Now the younger crowd listening won't remember, but you remember maybe 30, 40 years ago.
Yeah.
Maybe more, 50 years ago. Lee Marvin. Remember the actor?
I remember Lee Marvin.
Lee Marvin was married to somebody. I forget her name. I probably should remember because this is what kind of was one of the big high-profile cases that brought this to light.
Yeah.
And he was with her for 20, 30 years. And I don't know if he passed away or they walked away from each other.
Okay.
And she sued him for some of his property. And his whole defense was we were never married. And the courts awarded her certain property because she had developed an equitable interest in it. Now, it wasn't anything to do with divorce. You know what I mean? And that they called it palimony. Remember that?
I remember that.
They called it palimony. And in reality, I mean, that woman had a right to what she sued for but it wasn't in a divorce setting. It was so anyway. And now Tennessee also says we'll recognize a common law marriage if the common law marriage took place in a state that does recognize it.
Yes.
So Alabama does recognize it, and some people come here from there, and they will enjoy the recognition. So when I say they don't recognize it, it's not as harsh as that sounds. It just means, hey, don't come to the courts looking for a divorce because we can't give it to you. That's like going to the driver's. That's like going to. Well, maybe that might be right.
But so this happens when people have lived together. And basically live as a married couple, but they're not legally married.
That's right. I mean, common law marriage is, you take your vows before God. There's no governmental authority that solemnizes it.
Okay.
And like I said, the magic words when you're at a wedding, and at the end, if they say, "By the power vested in me by the state of wherever,"
Yeah, before God and the state of Tennessee.
State of Tennessee, let them.
Yes.
Which brings up a question, which I don't really want to get down this road, and I won't. But
Oh, boy.
I think about things like this, and it's like, people, everybody you know is married, right? I mean, everybody you know is married with a marriage license, right? I mean, maybe you know one or two folks like this,
Yeah.
but nonetheless.
Yeah.
So, my legal mind, that brings the question up, was there ever a time when people would get together and get married before the state of Tennessee existed that gives everybody the authority to be married? And the answer, of course, is yes.
Of course.
Yeah, of course. And it is a common law marriage. And common law marriage has been around a lot longer than the state of Tennessee. And what I'm going to say, I always say, if you want to research common law marriage, you can, and I have.
Yeah.
And it goes back, and it goes back, and it goes back. And I'm telling you right now, if you research it long enough, you're going to get your feet wet crossing the Jordan River, because it comes out of scriptural law.
Absolutely.
Our common law is founded on the scriptures. And the authority of God to marry people has been around a lot longer than any state or any governmental authority to give it.
Started with Adam and Eve.
It's actually probably an insult to him when you do it under Tennessee law, in my opinion. But, nonetheless, but that's the way it is. That's the way it is, because it's something they can, I won't go there, something they can control and get some money out of. But anyway.
Wow.
So if you're a minister and you can marry people, don't call me and complain. But again, that's an interesting topic. But nonetheless, it comes up. People that are married and not together, or together and not married. And, those are the what ifs. That's all started with the what if.
All the what ifs.
And there are a what if is something. There's going to be an end result of that. Now, the good news is, if we walk through it and the end result is something you don't want, we can fix it. We can make it the way you want it. We just need to know about it up front, right?
That's right. That's why you ask the question.
And if it's okay, if we walk through and say, yeah, that's okay with me, then we don't have to fix anything.
Right.
But I mean, it's not like, oh no, this is going to turn out this way, and my kids aren't going to get anything, and now you just worry about it for the rest of your life. I mean, we can fix it. Let's make it so that they get what you want it to.
Yeah.
I mean, you haven't given anything away yet. You haven't died yet.
Right. So, that's the other thing that I have to keep reminding myself. You set all these things up, but none of this happens until you're passing.
Exactly.
You're setting up a world that's going to be dealt with once you leave this world.
Yeah. And I often get the question and say, well, if I put in my will that I leave all this stuff to my kids, or my trust and I leave it to my kids,
Yes.
can I give some of it to them next year?
Yeah.
Well, certainly. You can give it during life anytime. You just don't have it to give it to them at death, like it says. I always say, let's say you got a Porsche in the garage, and you say, you write a will or a trust, and you say in there in no uncertain terms with a specific distribution, my son helped me rebuild his car, and he loves it to death, and we had bonding time messing with this car.
Sure.
I'm leaving the Porsche in the garage to my son because I just know he would appreciate it.
Yeah.
Now, somewhere before you die, you sell the Porsche
Yeah.
for whatever circumstances. Do you have to go change your will or your trust? I mean, you don't have to. You could, but I wouldn't recommend, especially a will, I wouldn't recommend spending the money to change the will.
Yeah.
We have a concept called redemption, which pretty much means you can't leave what you don't have.
That's correct.
So that clause in the will or trust, or whatever instrument is controlling descent and distribution, becomes a nullity.
Right.
Because you can't leave a Porsche you don't have.
That's
It's
right.
not like, it's not like you leave it to your kid. You can't go take it from the guy that bought it.
That's right. That's right.
You just don't have it to give.
Right.
So you don't have to change stuff. I mean, you
That's
could,
interesting.
but it's really not necessary. People ask that a lot, and I say, I wouldn't. Now, if there's a beaucoup change, if you have a trust and there's a boatload of changes, and you might want to do what we call restatement, which is like a gigantic amendment.
Yes.
And just to clean everything up.
Interesting.
That might be a situation, but
That's
only if there's a lot of changes that make the changes are so multiple that it makes the reading of the trust very cumbersome. We just do a complete restatement, that sort of thing. So it's you don't have to modify that, but you can. The concept of, the theory is it goes at death. It passes at death, but it can pass during life. But again, and during life, you can change these things. Even the irrevocable trust we do. Even the irrevocable trust we do, you can change where property goes at death.
Interesting.
You can't change what makes the irrevocable trust work, and certain certain ways it operates, but you can
Right.
certainly change where property goes at death. It's not the amendment process. It's something called exercising the power of appointment, which is just a little procedurally different. But the end result is if you say, I want to leave my kids a third, a third, and a third, and it's an irrevocable asset protection trust that says that, and you decide, I'm going to change this to 40%, 40%, and 20%.
Right.
You can do that in an irrevocable trust. That is not outside. You just do it by power of appointment, and so you can always modify this stuff. But yeah, technically it's at death, so nothing happens until then.
Well, this has been a very interesting discussion. I was going to ask you though, before we have to go, which we got about 8-9 minutes. Your seminars.
Yeah,
You got one coming up, don't you?
I usually start out with that, don't I?
Yeah, I just happened to remember we got one coming.
Yeah, we do. It's 2 weeks from tomorrow.
2 weeks from tomorrow.
17th. So it's February the 17th, and it is here.
That's right.
At the WLX radio station in the back, what you guys call the Country Cafe.
The Country Cafe.
Now, the Country Cafe is not really a cafe.
It's not.
I had some folks that were coming from a couple hours away last time we did this, and they called and said, yeah, we got the directions and said, yeah, okay,
Yeah.
we'll probably just stick around after seminar and have lunch there at the Country Cafe. And I had to say, well,
It's Country Cafe is just referring to country music.
it's
That's
not
what
exactly that
Yes.
kind of cafe.
Yeah.
But it's in the back of the building. And of course, on a Saturday seminar, we do those at 10 o'clock, 10 a.m. And I try to get started right on the money if I can. Sometimes if people are still trickling in the parking lot, I'll
Yes.
hold off 2 to 3 minutes, but usually by 10:05, usually not even that late, I'm starting. And it goes for about an hour to an hour and 15. It sounds like a long time, but I'll tell you what, when I give my seminars, I can see when I look out the room, I've got everybody's complete and undivided attention because they want to hear what we're talking about.
Yes.
We call it wills, trust, in the nursing home, and that's what we talk about. It's kind of not the Reader's Digest version, but it's certainly not a deep dive into this stuff because we could talk for hours on some of these concepts.
Right.
And on these shows, we do.
Yeah, we do.
But that's just get you, what it's designed to do is let you know that when it comes to this estate planning, there are options. There are
Yes.
lots of options. You just may not have heard of them.
Yes.
There are so many options that I guarantee you there's going to be one option that fits you and your family circumstances. Hits a nail right on the head. And you may not have known it was out there. And once you know it's out there, now you can do something about it. So,
Yeah.
Again, that's at 10 o'clock on Saturday. If you don't know where the radio station is, I think it's 1212 North Locust Street. You can put into your GPS.
that's correct.
Or look for that big old tower, biggest tower here in Lawrence County, right?
That's right. You can see it from anywhere in town.
And it's like the end of the rainbow. Where that tower hits the ground, there's a set of double doors.
That's
Walk
right.
in, you found it. That was it.
That's it.
But yeah, I mean, by all means, call my office and get on the RSVP list. And the RSVP list is very informal. We just like to get a head count. But call us at 931-363-7222. 931-363-7222. That's Pierchoski Estate Law, Pierchoski Elder Law. Or you can go to my website at Estate Plan Stand, ESTATE planstand.com. And there you can see the calendar. I think you can actually RSVP yourself from there.
Oh, okay. Well, that's good.
Or if you get the phone number, you can just call. That's
Sure.
pretty easy. Or you want to ask me a question, you can email me. Or you can set up one of my 15-minute phone calls where, those are pretty neat. They work out very well. We have these 15-minute phone calls. Now, I call them 15 lawyer minutes because they never last 15 minutes. But what we do is somebody will call with a question.
Yes.
And, of course, the calls get answered by my staff.
Yes.
I got 3 girls that work for me, and I couldn't do anything without them, but they're perfect. But when you call one and ask me a question, you are not getting past the girls if it's just impromptu. Just say you call at 10:34 in the morning and say, I'd like to ask Stan a question. What they're going to do is they're going to suggest that we make one of these calls. And it's good for me and it's good for you because here's what happens. In the middle of something, if you call me in the middle of the day, I'm doing something. My time is structured. They have me doing stuff all the time. They have me here for an hour. Right after here, they have me at the Register of Deeds office in the courthouse, and then they have me back there. So my time is structured. But what we do is we'll say, Mr. Stan will call you back. How about this afternoon, about 3:45 or 4 o'clock or something like that?
Right.
And now, what happened? And they'll take the question. What's the subject matter of what you want to talk to them about? And they're not asking to be nosy. They're asking so that they will give that to me. And before I make the call, I will look at your question and I'll give it some thought. Now, when I call you at 4:15 and you answer the phone, my time for the next 15 to 30 minutes is dedicated. 100%, my attention is dedicated to you and your question. it's not, because when you catch me in the middle of something, I'm switching gears. I'm thinking.
I understand.
It works better for me because I can give it some thought. Because sometimes the questions are pretty good questions, and I got to give it some thought. And I like to do so before I call.
Sure.
And say, okay, listen, I understand this is the question. Just fill me in on the gaps, and I
Right.
think I know where we're going to go, but I need to ask a couple more questions, stuff like that. And it works very well. I can give very good answers. You get a good answer. The time is meaningful. It's much more meaningful the time because it's structured and scheduled. And like I say, that works good for me and it works good for you. And you don't call and we schedule the call 2 weeks later. It's never like that for the phone calls. We always work. They're typically toward the end of the day.
Yeah.
And I think Alex will usually always say, if he doesn't call you today, it'll be tomorrow, but he will.
Yes.
It just depends on what I got going on.
Sure.
Today we have a very busy day. We got 2 trust signings. I think I got a couple other things. I mean, it's just going to be. If there's time for lunch, I'll be lucky.
I was going to ask you. Your time's winded up, so you've got a busy day today, but it's going to be a beautiful day. You're not going to get out and play golf or anything.
We try to take a walk around the square, a couple of blocks outside the square every day to kind of.
Teresa and I were in Pulaski last night, as a matter of fact. We went over to the little grocery store, Johnson's Food over there, and then we decided to go to the Hickory House and have dinner.
Yeah.
Before we came back home, and so I took a lap around the square, see what was going on, and all that kind of stuff. But what I was amazed at is how much traffic you guys have in Pulaski. It's kind of like Lawrenceburg.
Unfortunately,
there's a lot of people there.
Unfortunately, you saw parked in front of my office a giant dumpster and a big RV with a trailer.
I saw that.
Well, we're doing a lot of reconstruction work at the theater, which is right next door.
I assumed it was a theater, probably coming and going.
And they're installing a whole new lighting system.
Okay.
And it's a 3-day project. And they're from somewhere. They're from an hour or two away, and so they stay in this little RV parked right in front.
Okay.
So we called Chief Dickey, Chief Police, and said, "Hey, if somebody's sleeping out there, for the next 3 nights, is that okay?" He said, "Yeah, no problem. I'll tell the officers not to knock on the door and say what's going on here." And we got a big old dumper in the front that they're throwing stuff in and emptying. So
getting ready to remodel the stuff. Well, now you guys, you're involved in that. You got some big show plans coming up.
Yeah, the show that's coming up is called Children of the Holocaust. Pretty somber event. And it's a 2-part thing. It's the Children of the Holocaust and Can You Hear Them Crying? And it's kind of has to do with that. And
that's a serious
we usually always have somebody there that experienced that, and they talk a little bit about their experience when they were there, like from a military position of one of the liberators. People that got to a certain camp and took it down and got to run into the people that were there. So, but history.
That's amazing.
We can't change our history.
No, we cannot.
And it's best to just
and
embrace
we need to learn from it.
Well, that's right. If you're not foolish to talk about history, but you are foolish not to learn from it.
That's exactly.
whether it's good learning or bad learning.
That's exactly right. Right.
But so we're wrapping it up. Looks like we're in our last minute. So call
Stan
me.
Pierchoski, everybody.
Yeah, call us if you need to talk to us, and we'll be glad to talk to you. Or get on the list in 2 weeks from tomorrow for the seminar.
That's right. That's Saturday the 17th at 10 a.m. right here behind the studios in the Country Cafe. You've got a good seminar here with Stan Pierchoski Estate Law in Pulaski, Tennessee. That phone number, the office phone number, 931-363-7222. That's right.
Yep. Last one I did was probably in November around here.
Yeah.
I've done a few out other counties, but come on if you want. So
good deal. Have a blessed weekend, my friend, and good Lord willing, we'll see you next Friday.
You too, Jeff. It is always a pleasure to spend this hour on Fridays.
All right, we'll be back. I'm going to turn that up and turn that down.
This is WDXE.